Hello everyone, a very good morning. Welcome to the third session of our mini marathon for the BRBL paper. Today we'll be covering our module C, the most important questions from module C. And module C in total is a very important module. It holds around 25 to 30 marks weightage in your exam. So you need to study acts like the MSMED Act, SURFACI Act, IBC, the recovery of debts due to banks. Very important acts are there in your module C. So quickly, everyone join the session. Share the video with your fellow aspirants so that they can also join. We'll be following the same thing. I will show you questions on the screen one at a time. You will get 10 to 15 seconds to answer the questions. Drop down the answers in the comment box, and then we will discuss the correct answers and the theory related to it. All right, so I think we are good to go and we can start. All right. So here's the first question from your module C. Who is the appellate authority as defined in the Integrated Ombudsman Scheme of 2021? We are starting with a very simple, most basic question. When we are talking about the Integrated Ombudsman Scheme, we know that it has integrated the three existing ombudsman schemes: the Banking Ombudsman Scheme of 2006, the Ombudsman Scheme for NBFCs 2018, and the Ombudsman Scheme for Digital Transactions 2019. All of these have been now subsumed under the Integrated Ombudsman Scheme of RBI in 2021 under the One Nation, One Ombudsman. Okay, so here this ombudsman has the responsibility to hear complaints of deficiency in services. Wherever a customer faces a deficiency in services, banking services, and if their complaint is not resolved by the respective bank, they can take it to the RBI ombudsman. They can file the application online, or they can make a written complaint to the CRPC. And if they're still not satisfied with the decision taken by the ombudsman, they can also escalate it to the appellate authority. So, who is the appellate authority under this scheme? Is it the advocate appointed by the complainant, or a person appointed by the bank, the executive director in charge of the department of RBI administering the scheme, or the ombudsman appointed by RBI is the appellate authority? So, what is the correct answer? Comment down your answers, everyone. Right, so the correct answer here is the executive director in charge of the department of the RBI administering the scheme. Other than that, other important definitions, there's also the appellate authority, secretariat, authorized representative. The customer who faces a deficiency in service can themselves make a complaint, or if they do not have enough knowledge, they can appoint any other person other than an advocate. A duly appointed authorized person other than an advocate that would represent the complainant in the proceedings before the ombudsman, right? Then we have the bank, ombudsman, deputy ombudsman, regulated entity. All of these things are there. All right. Now, from your, I am good. Thank you so much, Irfan. How are you? All right, so let us move on to the next question from your module C and module D. Case study questions and scenario based questions are also asked. So here's a case study for you. Sanjeev, a small business owner, had issued with ABC Bank concerning a loan rejection. He filed a complaint with the ombudsman arguing that the bank's commercial judgment was unfair. However, ABC Bank defended its decision, stating that the loan rejection was based on an internal policy and risk evaluation. Meanwhile, Sanjeev had also filed a similar case in court seeking damages. Ombudsman reviews the complaint and must decide whether the complaint is maintainable under clause 10 or not. So the clause 10 of our ombudsman scheme gives the list of those complaints that are not maintainable. Earlier, such list was not there, and the ombudsman did not give reason why they are rejecting the complaint of the complainant. Now, in the integrated scheme, these matters are clearly mentioned. So, what will be the decision? Why would the complaint be rejected? Because ABC Bank failed to provide a written response within 30 days, or the ombudsman must always entertain complaints related to loans because the complaint was filed without legal representation, or the complaint challenges the commercial judgment of the bank. So, the complaint made by the complainant, the customer, should be related to a deficiency in service. They cannot challenge a commercial judgment or decision of the regulated entity. And here they are saying that the Sanjeev said that it was a commercial judgment that was unfair. So it will be rejected on the ground that the complaint was against a commercial decision. Other than this, any dispute between a vendor and regulated entity relating to outsourcing contract non-maintainable, grievances not addressed to the ombudsman directly, grievances against the management or executives, disputes initiated by the regulated entity when they're complying with statutory orders, disputes between regulated entities, these are non-maintainable. All right? Okay. Next. What is the maximum compensation amount that the ombudsman can award according to the clause 15? So, what is the procedure? A customer has a complaint, they will first make the complaint to their bank itself, the financial institution. The bank should give a response within 30 days. If no response is given or the customer is not satisfied, then they can escalate it to the ombudsman. What will the ombudsman do? Ombudsman will give a notice to the bank within 14 days, present your cause. Show me the documents related to the customer's complaint. After that, the ombudsman is going to hear both the parties and then they will award a compensation. Right? So, yes, the correct answer is rupees 20 lakh or the consequential loss suffered, whichever is lower. All right. Also, for any mental anguish due to repeated visit of the bank, costs incurred on the repeated visit of the bank, additional compensation up to 1 lakh rupees, not exceeding 1 lakh rupees, can also be awarded. All right, the copy will be sent to the complainant and the regulated entity. The complainant should furnish a letter of acceptance, and the within the 30-day period, it should be finally settled. All right, appeal can also be made to the appellate authority again within the 30-day period. Right, ex parte decision will be taken by the ombudsman. In this type of decision, bank lose their right to make an appeal to the appellate authority. All right. Okay. Next question. Which of the following statements correctly reflect the statutory provisions under Chapter 5 of the MSMED Act regarding delayed payments to the MSME suppliers? You read the statements. Till then, let me just, in short, explain to you the MSMED Act to facilitate the promotion, development of the micro and small enterprises. Under this, we also have a national board for MSMEs and advisory committee that give advices to the central and state government how to better utilize their funds, how to prepare new schemes, implement them for the facilitation of the MSMEs. There's also the MSME Facilitation Council. If there is any dispute between MSME and bank, MSME and customer, they will be dealt by the Facilitation Council. Talking about the delayed payment. See, MSME's definition has been revised. according to their investment and turnover. If the MSME falls under those investment turnover criteria and they supply goods to their buyer, the buyer within the stipulated period, either it will be the appointed day, or it will be whatever date is agreed by between the buyer and the seller. If they do not pay the money that has been agreed, then it is known as a delayed payment. For this, you also need to understand the concept of appointed day. The day immediately following after the expiry of 15 days on which the day of goods were delivered, right? 15 days from the day on which the goods were delivered or the services were rendered, or if let's say the buyer had a problem, so on the day on which it was resolved, after 15 days, the 16th day is the appointed day. By the appointed day, payment has to be done by the buyer. I hope the appointed day concept is clear. Now let us one by one go through the statement. The buyer must make payment within 45 days from the date of invoice, irrespective of any agreement. Is this true? No. This statement is incorrect. I will tell you why. If no written statement agrees, then the payment must be made before the appointed date. Yes. Before 16th day of the delivery, payment must be made. The interest payable on delayed payment is simple interest at twice the bank rate notified by RBI. No. The interest rate is higher. All right, it is higher. It is three times. Also, it is not simple, it is compounded, right? And statement D, the buyer is liable to pay, yes, compound interest with monthly rest at three times the bank rate. So the correct answer is A, B and D only. B and D only. All right. Why statement A is incorrect? Because when the supplier supplies any goods, the buyer has to make payment on or before the date agreed upon between them. Right. So if a date is agreed on between them, then this 45-day rule will not apply. Right. Max, or if no agreed date is there, then the appointed day. Even if the date is agreed, it will not be more than 45 days. All right, it shall not exceed 45 days. And if the buyer delays, they are liable to pay compound interest rate at monthly rest from the date immediately following the agreed date or the appointed day at three times of the bank rate notified by RBI. All right, so that is the provision regarding delayed payment. Then, other than this, from the MSMED Act, nothing as such is important. This was the most important part. I've already told you about the advisory committee, the national board, the facilitation council, right? The facilitation council disclosure and penalties contravention, not that important. Now we come to the most important act of our module C, SURFACE Act. Which of the following conditions must be mandatorily satisfied by a company before commencing securitization or asset reconstruction activities as an ARC? So what is securitization? When the bank, they prepare a pool of assets. They can be standard asset, they can be NPA as well. Homogeneous pool. They transferred it to the ARC or the special purpose vehicle, right? They transfer the pool. The ARC make an immediate cash payment or they can issue debentures. Then the ARC issues security receipt and the derivative is this pool of asset. The ARC will receive their payment from the investors. The investors will get their interest from the ARC. They will pay it from the loan repayment, or if it is a default, then by the selling of the property. Like this, it works. But before this entity starts the business of asset reconstruction securitization, it is important that they apply and get registration from RBI. Without RBI approval, it is not allowed. right? So it is important that they obtain a certificate of registration. It should have net owned funds of not less than 2 crore rupees or higher specified by RBI. Holding of equity shares by at least one scheduled commercial bank, not important. Clearing of at least one successful acquisition, no. Before they apply for registration, they cannot undertake any acquisition proposal. So statement 3 and 4 are incorrect. The correct answer is C, 1 and 2 only. All right, 1 and 2 only. So RBI will check certain things, that the ARC has not incurred losses in the preceding 3 financial year. They have adequate arrangements for the realization of financial asset. The directors have adequate professional experience. Directors should not be convicted of any moral turpitude. The sponsor should be fit and proper. ARC should comply, they should be in a position to comply with the prudential norm. All of these things, RBI also has the right to cancel the certification if the ARC fails to comply with any of the direction. All right? Okay. Which of the following are valid statutory measures that the security creditor may adopt under SARFAESI if the borrower fails to discharge liabilities? Now, this is for the reconstruction. If the borrower defaults, what can the ARC do? Take possession of the secured asset and transfer it by the sale of lease, sale or recovery. Second, take over the management of the secured asset, including authority to transfer or lease it. Appoint a manager to oversee the secured assets in their control. Demand direct payment from third party who owe money to the borrower to the extent of the secured debt. What actions can the ARC take? What actions can the ARC take? Answer this question. Which statements are correct? For the enforcement of security interest when the borrower defaults. So, the ARC has the right to take any and all of these action. No, not A. All of the above are correct. All right, they can take possession, they can take managerial control, appoint managers, the receivers, they can also redirect dues. So let's say borrower A had defaulted, some other person B had to pay debt to A. Bank will direct them directly to pay the debt. And if B fails, B will also be deemed guilty. All right, they have to comply with the regulation. All right, next question. Which of the following statements are true regarding the appellate remedies under the SARFAESI Act? Under the SARFAESI Act, without court intervention, the bank can directly take action. They can, after giving notice to the borrower, sell off the property. They can transfer the property to the ARC, or they can also approach the DRT. Taking court permission, court intervention not required. Now, if let's say the bank had taken any action and borrower or any other party is aggrieved by it, they have the right to make an appeal to the appellate authority. So, what are the conditions? Appeal before the appellate authority must be filed within 30 days from the date of communication of the DRT's order. To file appeal, borrowers must deposit 50% of the debt amount claim, that can be reduced to 25%. Appeal may be entertained even if consent orders are passed by the DRT, if consent was obtained under duress or misrepresentation. If the DRT fails to dispose of the borrower's application, the borrower may directly approach the Supreme Court. So, first application, the original jurisdiction is with the DRT. The DRT will hear both the parties, pass an order. If someone is aggrieved by the order passed by DRT, they can also make an appeal to the DRAT. Making an application to the DRT, no fees, no deposit has to be made. But making the appeal to the appellate authority, deposit of 50% is required, right? Within 45 days to the DRT, within 30 days to the DRAT. But if the order was passed by the DRT with the consent of both the parties, no appeal can be filed. And if the DRT fails to dispose of the borrower's application, they can directly take it to the DRAT, not to the Supreme Court, except for the writ jurisdiction. If it is a relation to a question of law, Supreme Court, High Court, Civil Court will have no jurisdiction under the SARFAESI Act. Only the DRT and the DRAT, their orders will be final. All right, so the correct answer is C, 1 and 2 only. All right, 1 and 2 only. Next. According to the section 26C of the SARFAESI Act, what is the effect of registration of a security interest? Under the SARFAESI Act, the SARSAI has been established as a central registry to maintain a central register by the central registrar of all the charges created, modified, satisfied, of all the security interest, securitization, reconstruction, everything. There are charges from Form 1 to Form 10 that need to be submitted, right, in the prescribed form, paying of the fees and so on. So what will be the effect of registration of the charge with SARSAI? It amounts to constructive public notice from the time and date of filing. Any subsequent transfer of charge is deemed subject to the earlier registered charge. A borrower's sale of such asset in ordinary course of business is void even if it precedes the registration. The registered attachment orders take precedence over the unregistered security interest, regardless of actual possession. So, what is the impact of registration? This we have discussed so many times. When a bank gives a loan and they get the charge registered, they will become secured creditor. This means they will have priority over all the other subsequent charges. So, any other subsequent charge that is registered will be subject to the previous registered charge, right? And the subsequent bank or the creditor should first check before giving out the loan whether the property is available, encumbered, or unencumbered, right? But before the charge gets registered, if the borrower sells the asset in the ordinary course of business, it will not be declared void. All right. Transactions which are carried out in the ordinary course of business are not void. And fourth, registered attachment order, they are given priority over the unregistered orders. So the correct answer is B, 1, 2, and 3. Even in the SARFAESI Act, only those loans that are covered by a security, only the secured creditor is taken into consideration. And the unsecured creditors, they will not get, mostly they will not get their dues when we follow the waterfall arrangement. All right, so I hope this is clear. Next. Which of the following combinations accurately reflect the structural and qualification requirements for the DRAT chairperson? So the DRT highest officer is the presiding officer appointed by the central government. They have to be eligible to be a judge of district court, and their term of office will be 5 years or 65 years of age, whichever is earlier. When we are talking about the DRAT, there has to be a chairperson again appointed by the central government. All right. The DRT and the DRATs are established under which act? Under the Recovery of Debts Due to Banks and Financial Institutions Act of 1993. The constitutional validity of this act is also important. The whole story, how the Delhi High Court declared it unconstitutional, then the Supreme Court declared it constitutional to set up special courts. Okay, so the qualification for the chairperson, the appellate tribunal comprises multiple judicial members and is headed by the chairperson. Is it true? No. Only one person, chairperson, will be there. Then the person who has held the office of presiding officer for 3 years may qualify. Yes. The qualification for the chairperson eligible to be a judge of High Court plus served in the Indian legal services in the grade for 3 years or presided as a presiding officer of any DRT for 3 years. Then also they will be eligible. The central government may notify the chairperson of one appellate tribunal to discharge the functions of another. Yes, the central government can do that. If the presiding officer is selected to discharge the duties of another presiding officer, that decision is taken by the chairperson. The maximum age of retirement of DRAT chairperson is not 65 years, it is 70 years or 5 years of office, whichever is earlier. So the correct answer is 2 and 3A. All right, 2 and 3A. Volume is low. Um, Volume is fine from my side. Others are also facing this issue. There should not be issue here for the volume. It is fine, right? We can try to adjust your device volume once. All right? Okay. Let's move on to the next question. And please answer the questions. You all are active here, so try to answer. Which of the following statements does not correctly reflect statutory and judicial provisions regarding the jurisdiction and supervisory powers of the DRT and appellate tribunal? So, DRTs and appellate tribunal, they are given some powers. Which of the following statement is not correct about these powers? The DRT can entertain application for the execution of foreign decrees as upheld in the Bank of India versus the Harshad Rai Odavji Modi case. The jurisdiction of the tribunal includes application under the Part 3 of IBC with mandatory circuit sittings. The chairperson may transfer cases between the presiding officer without hearing the parties in its own motion. Or D, the chairperson may recommend inquiry against the presiding officer for incapacity. Which of the following statement is incorrect, not correct? So, first statement, if a foreign decree is given but not yet executed, it can be executed by a DRT, and this case mentioned here is correct, right? If the application under IBC have to be resolved, yes, it is also correct. The recovery officers attached with the DRTs can be used here. The chairperson of the appellate tribunal can transfer cases between presiding officers through, but not without hearing the parties. All right. So if let's say the chairperson, the presiding officer is absent, they are incapable, unable to perform their duties, the cases can be transferred, but both the parties should be heard. So this statement is incorrect. And the chairperson can also recommend inquiry. Let's say the presiding officer is found to be incapable or involved in some misbehavior, corruption, the chairperson will give a written report, conduct the inquiry, give a written report. The reason for the inquiry, they will send it to the central government. The central government will conduct the proceedings and decide whether or not to remove the presiding officer. So the statement is also correct. So the correct answer is C. Without hearing the parties, they cannot transfer the cases between presiding officers. Also, only those DRTs that come under the jurisdictions of the DRAT, only between them, the cases can be transferred. All right. Which of the following statements does not correctly reflect the statutory and judicial framework governing the recovery proceedings under Section 25 and validity of the recovery certificate? In the live class today, in the morning, we have discussed this topic. I want you to answer this. The recovery officer may arrest and detain the defendant in person, but only after establishing willful default despite sufficient means in line with the Article 21 safeguards. The defendant may raise objection before the recovery officer regarding the correctness of the certificate amount, provided it should be supported by affidavit. The recovery officer may recover dues by taking possession of the secured or other property and appoint a receiver for its sale. The review of the recovery certificate on grounds of apparent error must be filed within 60 days, supported by the affidavit. So, what action can the DRT take for the recovery of debts? They can they will pass the recovery order, they will appoint a recovery officer, right? The recovery officer will be appointed, given the responsibility to prepare a whole inventory of the other assets if the property falls short to recover the debt, right? They will pass the attachment order. They can also remove any person from the custody of that property. They can restrain the defendant from disposing of the asset. You are saying A, but the question is asking you, it does not correctly reflect. You need to answer the incorrect statement. Incorrect statement. The incorrect statement is that the defendant may raise objection. The defendant may not raise objection. If they have any issue with regard to the recovery certificate, they cannot make any objection to the recovery officer. They can file a review application to the DRT within 60 days. Within 60 days. And the recovery officer should also refrain from entertaining any of these complaints. All right, so the statement B is incorrect. Other than that, the recovery officer may arrest and detain the person, the defendant, but not if they are hit by poverty, they are genuinely not able to pay the debt, then imprisonment cannot be given. The recovery officer can also stay the proceedings. The recovery officer can, when prepare an inventory, the DRT can require to prepare an inventory of the other property and asset. All of these things are there. But to raise objection, they need to make an application to the DRT within 60 days, not to the recovery officer, right? And if, let's say, any review is successful, the DRT is changing anything in the recovery certificate, they need to inform it to the recovery officer to take action accordingly. We also studied that how stay on the proceedings can be granted if the defendant makes a down payment of 25% of the award ordered by DRT. So all of these things are there. Again, a scenario is given. Secure ARC Limited, which is an asset reconstruction company, acquires the distressed financial assets from multiple banks and issued security receipts to the institutional buyers, the qualified institutional buyers. A group of qualified institutional buyers collectively own 80% of the total security receipts. However, due to non-realization of certain financial assets, the buyers decide to invoke their rights. They call a meeting to determine further action. Meanwhile, an individual investor also attempts to purchase the security receipt, right, arguing that the ARC should allow public investment. So, since the qualified buyers collectively hold more than 75% of security receipts, what action can they take? Transfer their security receipt to individual investors because they are requesting it, liquidate the secure ARC without court approval, call a meeting, pass a binding resolution, force secure ARC limited to invest in additional distressed asset. So the qualified institutional buyers, if they hold more than 75% of the security receipt, in the event when the ARC is unable to pay them the investment money, in that case, they will hold a meeting, they will discuss, and they will pass orders that would be binding on the ARC. They cannot liquidate the ARC, they cannot allow individual investors to participate, nor can they force the ARC to invest in additional distressed asset. All right. Okay, so everyone who's present here, please like the video so that I can understand you are here also. Please try to be active. Try to answer the question even if you get it wrong. Doesn't matter. Right? We are just revising. All right, next question. Which of the following combinations correctly matches the terms to their definitions under the code? Under which code? Under the IBC. The Insolvency and Bankruptcy Code. So, the Insolvency and Bankruptcy Code of 2016, there are certain definitions. First, you need to understand the difference between insolvency and bankruptcy. Insolvency means the individual, the organization is unable to meet its outstanding financial debt, but it can be resolved. They can be brought out of the insolvency situation by changing the payment plan or by changing the management, anything. It is not necessary that it is to be liquidated. Bankruptcy is different. Why? Because in this, it is clear that the corporate will be unable to pay the debt no matter how much rescheduling, change in management is done. So the company will be liquidated and the personal property will be handed out to the creditors. This is the difference between insolvency and bankruptcy. Now, there are different types of creditors: financial creditor, operational debt, corporate debt. All of these are there. So, you need to select the correct statement. Financial creditor, a person to whom a debt arising out of provision of goods or service is owed. Is it true? No. Where only a financial debt involving money is owed. That is a financial creditor. Operational creditor, a person whose debt arises from employment services as government due. Yes. Operational means some operations had to be conducted. Some functions, duties had to be performed by another person. They had promised it to the creditor, so that is the operational creditor. Corporate debtor, to whom a financial debt is owed. No. Who owes a debt, that is operational nature. Financial debt for consideration of the time value of money including interest. So which of the following statement is correct? It correctly matches. Operational creditor is correct and financial debt is also correct. Right? A debt disbursed for the consideration of money including interest. So correct answer is D, 2 and 4. Correct answer is D, 2 and 4. Operational creditor, to whom a operational debt is owed. Corporate debtor, a company who owes a corporate debt. All right, not a financial debt, corporate debt. So the correct answer is D. Okay. Consider the following orders of claims in liquidation. Identify which of these pairs are correctly ranked as per the waterfall mechanism. So we have studied in all of these acts, the secured creditor obviously gets priority. According to the waterfall arrangement, first their dues will be paid off, then whatever remains will be distributed among the other creditors, the other people to whom any debt is owed. So wages and unpaid due to the employees for 12 month rank above dues to the unsecured financial creditor. Dues to the government rank above debts to the secured creditor who enforce their security outside the estate. Dues to the workmen for 24 months preceding insolvency rank above resolution. Preference shareholders are ranked below the equity shares. So, which of the following statements are correct according to the waterfall arrangement? See, fourth statement is incorrect. The preference shareholders they rank above the equity shareholder in the waterfall arrangement, right? Also, the government dues are definitely they will come after the secured creditor, but here they are saying the secured creditor enforce their security outside the estate. The secured creditor, if the corporate insolvency resolution plan is initiated against the corporate company, they can give their security interest to the receiver. In that case, they will get priority. If they do not and they want to enforce their security interest independently, then they will not get priority and the government will rank above the debts owed to them. All right, so the correct answer will be 1 and 2 is correct. 3 is also incorrect. Dues due to workmen for the 24 months preceding the insolvency rank above no. First, the insolvency costs, the liquidation costs are paid. Then the workmen due, the unpaid dues to employees are paid. So the correct answer is A, 1 and 2 only. 1 and 2 only. All right. So this is the waterfall arrangement. All right. Okay. So first, the insolvency resolution and liquidity costs will be paid. Second, the secured creditor and the workmen dues will be paid. Secured creditors who have relinquished their security. They have given their security to the receiver. After that, employee wages and dues other than workmen will be paid. Then will come the financial debts owed to the unsecured creditors, government dues, and then we will have the financial shareholders, and finally we will have the equity shareholders. All right, so in the hierarchical order, in the predetermined sequence based on priority, the dues are paid under the CIRP. All right. Next question with reference to the evidentiary nature of entries in bankers' books and relevant case law, consider the following statements. So, Bankers' Books Evidence Act is another act given in our module C that talks about that giving or producing of original bankers books is not necessary in any civil case. The certified copies can also be presented. So which statements are correct? A certified copy is evidential equal to the force of original entry itself. Yes, correct. Such certified copy is sufficient to fasten civil liability even if the entry is disputed. No, if the exact bank document itself is disputed, the complainant, the defendant, they are saying that this copy itself, this entry in the bank's book is incorrect. No such transaction was done by me. Then the original document has to be submitted. Certified copy will not work. Second statement is incorrect. If the entries are accepted by the party concerned, no further proof is required. Yes, this is true. In the decision of Chandrahar Goswami versus Guwahati Bank, clarifies that entries alone do not suffice unless collaborated. This is also correct. It means that if the parties are satisfied that the entries are enough, we know that these are correct, then they will be sufficient evidence. Otherwise, they do not suffice. Certified copy should be given along with it. So the correct answer is 1, 3, and 4B. All right, 1, 3, and 4B. Okay. In a civil suit, which of the following statements accurately capture the evidentiary protocol regarding the production and inspection of the banker's books when the bank is not a party to the proceeding? When the bank is not a party to the proceeding, what is required to be provided by the bank? The bank officer is legally compellable to produce original banks? No. Unless ordered by the court specifically or the bank is itself involved, original documents cannot be forced. Copies will be accepted. Then, if certified copies are produced, no bank officer can be summoned to prove yes. If certified copy is there and the bank is not actually involved, no officer will be forced to come and give their witness. Parties may apply to inspect original entries, but the court may allow it with only in special circumstances, and the bank may object to the production of certified entries and request to show cause prior to complying with the court order. So, which statements are correct? 2, 3, and 4. If the bank allows, they will be, if the court says that you need to provide the certified copy, then the bank has to provide it, otherwise not. All right, so statement 1 is incorrect. Bank officers cannot be compelled unless ordered by the court for a special cause. Okay, next. Consider the following with respect to the jurisdiction and limits of the Lok Adalat. Now, the Lok Adalats are established under the Legal Services Authorities Act of 1987. This is the fastest, cheapest mode of recovery of dues, right? So, which of the following statements are correct? Matters pending before a court, not yet instituted but within the jurisdiction, may be brought before a Lok Adalat if both the parties, first the matter was given in the court, fees was paid, both the parties agree, or the court thinks that it can be resolved by the Lok Adalat, it can be transferred, yes. Compoundable offences under prevailing law may be referred. Compoundable offences are those in which the offense is related to the criminal misconduct. All right, there's a difference between compoundable and non-compoundable cases. Okay, so compoundable cases that serve severe criminal offenses, right? And the victim and the accused, they can less severe, means they are not very high criminal cases, right? Both the parties, if they agree to a common ground, they can set off the legal proceedings. So only compoundable cases that are less severe can be brought here. Non-compoundable cases where there is any, let's say, a murder is involved or a very large harm is involved, that cannot be brought to the Lok Adalat. All right, so the compoundable offences under any law can be referred, yes. Civil disputes up to a prescribed monetary ceiling of 20 lakhs can be settled through the Lok Adalat. This is also true. Above 20 lakhs, DRTs and the Surface Act. Below 20 lakhs, it can be taken by the Lok Adalat. Lok Adalat have the power to adjudicate and issue binding decision? No. The Lok Adalat is going to solve the issue by mediation, conciliation, and with the consent of both the parties. If the consent is not there, the case will be transferred to the civil court or the DRT or whatever the parties want. So the fourth statement is incorrect. Rest everything is correct. 1, 2, and 3 is correct. All right. Okay. Next question. Which of the following powers are exercisable by the Lok Adalat and the permanent Lok Adalat? Requisitioning public record from any government office, administering oaths and examining witness, framing charges in cognizable criminal cases, receiving evidence on affidavit. Very clear. We have already discussed those cases which are not compoundable, which cannot be resolved through mediation and reconciliation, cannot be taken by the Lok Adalat. So the correct answer is 1, 2, and 4. Third statement is incorrect. Okay. What is the jurisdiction limit for the district commission to entertain complaints? Now, there are three acts which are not that important. One of them, the law of limitation, tax laws, bankers books evidence act, consumer protection act also. It only a few topics are important, like this one. Under the consumer protection act, the concept of unfair trade practice or unfair contract is given. Wherever a consumer faces an unfair trade contract, they can make a complaint. This is known as a consumer dispute, right? They can make a complaint to the central, state, and district consumer protection council. There are also the central consumer protection authority, which is formed, and the consumer disputes redressal commission. Okay, when we are talking about the district commission to entertain complaint, we are saying the dispute redressal commission. So what is their limit? When the case exceeds 50 lakh rupees, does not exceed 50 lakh, exceeds 2 crores, or does not exceed 2 crores. The district commission will entertain complaints when it does not exceed 50 lakh rupees. All right, 50 lakh rupees. The state commission exceeds 50 lakh, not exceeding 2 crore rupees, and the national commission, where the amount involved in the dispute exceeds 2 crore rupees. All right, so their jurisdiction is important. Next, what time is excluded when computing the period of limitation? So, what is a period of limitation? When the complainant or the bank or anyone wants to make a complaint, there's a time bar duration. Within 3 years, within 12 years, within 30 years, they need to make the complaint. But when we are computing this period of limitation, we exclude something. What is it? The time taken for obtaining a copy of the order, for filing of the case, court to hear the appeal, or time taken for appellate court to respond. When we are computing the limitation period, we exclude the time taken for obtaining a copy of the order. Right? When the court is closed, that will be excluded. An appeal or application, if it is made, it can be accepted. Okay, the day from which the period is to be reckoned is also excluded. Computation will exclude the day on which the judgment was pronounced or the time taken to obtain a decree, sentence, or order appealed. All right. Okay. Last question. What is true about the income declared by resident assessee? So the taxation depends upon the residential status, not upon the citizenship of any person. Residential status means person will be a resident of India if their stay is more than 182 days in the preceding financial year, or more than 365 days in the preceding 10 years, and more than 60 days in the immediate preceding financial year. If it is not fulfilled, they are a non-resident. So the classification is different. The resident Indian is charged on their income they earn in India as well as on their foreign income. So their global income is charged, but a non-resident is charged only on their Indian income, not on their global income. All right, so what is true? It includes the income from anywhere around the world. Yes, global income is charged. It includes income only earned in India. No, this is for the non-resident Indian. It is taxed only if the income is earned within India. Again, incorrect. It is taxable. Yes, under the Income Tax Act. So the correct answer is B, A, and D. B, A, and D. I mean, second option. All right. So the taxability depends upon their residential status. If someone is a citizen of India, but they leave India, they're residing abroad, they're taking up employment, they are conducting any business or vocation, they will be charged tax by the government there. If they're earning any additional income from India, then the Indian government can tax them, otherwise not. So that is all for today. We have completed the most important questions, but the module C is quite lengthy. There are other topics also that we need to cover. We'll be covering it in our marathon sessions. So this is the mini marathon covering only the important topics. We have one more module left. We will do it in the next session. All right, so if you want to start your preparation with us, you can join the CIB Super Elite Plan. You will get access to all the courses. We have also started with the crash batches, and very soon we'll be entering into the cracker batch. So you can also join the all-in-one combo crash plus cracker. Okay, so that is all from my side. I hope everything was clear, and you can download the PDF. You'll get the link in the description box. You can go on the Oliveboard website. Under the courses section, you'll get the PDFs. All right. So thank you so much for attending. Thank you so much for participating. If you have any doubts, you can comment them. Like the video, share the video, subscribe to the channel because we'll be bringing these important sessions. Your exams are very close now, so gear up and give your 100% towards preparation. All right. Thank you so much. Have a great day. Take care and all the best.